Hello, everyone. Welcome to the program, Protecting Your Family and Leaving a Legacy, Why Most Estate Plans Fail and What You Can Do About It. Really glad you're with us, and I thought it would be appropriate to start out by telling you my story, the why, if you will, of why I practice estate planning law and how that came about. It all occurred because my dad, living in Northwest Missouri, in a small county seat town, got up one morning with a sore throat and went to the doctor, and the doctor suggested that he spend some time on the farm where he wouldn't have to talk to anyone rather than go to work in town. So he took off and went to the farm and got on his John Deere 4020 and started bringing the big round bales of hay up to the barn. Well, as fate would have it, he backed into a big bale, turned to the right, and the centrifugal force of the weight of that bale on the side of a hill, early morning dew on the grass, caused the tractor to start sliding sideways. And it continued to slide a few feet until the left rear wheel dropped off over the edge of the ditch. And the sliding continued. The tractor rolled over sideways onto him and landed on him at the bottom of that ditch. So my dad lost his life that day on a farm where he was born. And the reason that became my why and inspired me to set up my estate planning law firm is because, sadly, my dad died without an estate plan. And the challenges that my mother and I faced after his death, dealing with probate, dealing with the IRS over the value of a closely held business and a small farm, was, shall I say, more than aggravating. It was very, very frustrating and very painful for my mom, because it seemed like every time we went back to court, every time we had to deal with the IRS, we had to relive the loss of my father. And so inadvertently, and again, as I said, sadly, my dad, my best friend, became the inspirational founder of the law firm we know today as Parman and Easterday. And it's that experience that inspires me to share the story of why it's important for people to plan today and how you can go about it, and share some of the problems with planning, what can go wrong, and hopefully set you on a path to creating a good plan for you and your family so you can avoid the perils and the pain and the headache and the time delay in distributing your estate that my mother faced upon the death of my father. So I thought it was important for you to hear that, for you to know that, and for me to share that with you, hopefully as a reminder about why I'm doing what we're doing today, sharing a message. How we go about that is by carefully listening to you to be sure that your goals and your objectives correctly get stated in your estate plan. And the deliverable product, of course, is the plan itself. I'm Larry Parman, founder of the law firm Parman and Easterday, with offices in Oklahoma City and Kansas City. I am an author. We have written a couple books, which I'll tell you about in a moment. My practice focus and our firm's practice focus stays purely within the rails of business and estate planning. Estate planning broken down into the pure estate planning processes we'll talk about today, as well as elder law, which we'll touch on a little bit as well. I'm a certified estate planning specialist with the National Association of Estate Planners and Counsels. Had a little public service in my background. I had a wonderful opportunity to serve as Oklahoma's Secretary of State as well as Secretary of Commerce. Extraordinary experience, and I learned a lot from that, all of which serves me well today. Our firm is a member of the American Academy of Estate Planning Attorneys, in addition to the legal services that we provide. We also have a strategic alliance with a firm that is part of our organization. It's a registered investment advisory firm, and through that firm, we also provide financial investment planning services, retirement planning services, and we help families bring together in a coordinated way their estate planning as well as their financial planning. We frequently lecture on different estate planning topics and have written different articles from time to time that have been published in the Daily Oklahoman and other places. Earlier, when I mentioned books, we literally wrote the books. Here are three: Guiding Those Left Behind in Oklahoma and Estate Planning Basics deal with the estate planning side of our practice. Stop and Think was a book that dealt with investment planning, and I co-authored that and wrote a chapter in that book on asset allocation. And then a few years ago, I individually wrote a book called Above the Fray: Leading Yourself, Your Business, and Others During Turbulent Times. That was a book that was inspired primarily by my business owner clients who were struggling with certain parts of their business, and we were able to help them not only grow their business, the top line revenue and the bottom line revenue, but position their company to be sold for the maximum price when they were ready to exit. So I appreciate you being here. Have to say congratulations. I doubt many of you spend a lot of time thinking about death and taxes, nursing home expenses, the possibility of families being torn apart if you fail to correctly plan, and the idea that you may have some uncertainty about being sure that you create a plan that actually works, that works exactly the way you want it when you set it up. So I appreciate you being here. Here's the agenda we're going to follow today. First of all, a little bit of a discussion about the context that we face today in our country. We'll talk about why traditional planning fails so many Americans, and then we'll get right into a story, version 1 and version 2. The first version will deal with failed planning. What happens if you do nothing, or what happens if you incorrectly plan? And then we'll come back and hit a reset button, and we'll talk about successful planning, the ingredients of that, what it takes to create a plan, how you go about it. And we'll include in that discussion the benefits of broadening the scope of traditional planning to include legacy planning. We're going to ask you a question and visit this 2 times. What do you think is the most important and most critical part of setting up an estate plan? And then finally, we're going to give you a roadmap about how you can take specific steps toward getting your plan created. Let's talk a little bit about the context. Where are we today? Certainly, these are challenging times in America. You only have to read the first page of a newspaper or turn on the news for just a moment to hear about the lawsuits being filed and the petitions for bankruptcy into the millions. Since 2000, in fact, over 6 million families have filed for bankruptcy because of crushing medical expenses. Nearly 650,000 this past year alone. We also know that America has one of the highest divorce rates in the world. And when a family creates a plan and then experiences a divorce, that can have a profound impact on the estate plan, certainly on the family itself. More and more, all of us are hearing about the ravages of long-term health care, specifically the exploding cost of nursing homes. In Oklahoma County alone, those costs are approaching $75,000 per year. In many parts of the country, well over $100,000 per year, and that's before the medications and so on and so forth. We also know that many of you listening today, participating in this webinar, are caregivers. Over 40 million people in this country are providing aid to family members and close friends, and so that's creating additional pressure on the family unit as well. And then we also know that because of poor planning, confusing planning, that we're having more litigation and courts are dealing with countless lawsuits because plans are being challenged, plans are being overthrown because of poorly worded trust, poorly worded wills, and plans that just don't work. So given that context, when people come in to visit with us, we typically hear these 6 concerns expressed with great frequency. First of all, no one wants the government or courts interfering with the transition of their assets from themselves to their family members. They want that transition to be smooth. They want it to be easy. They want it to include the least amount of possible cost and avoid all taxes if possible, and the fees. They also want that transition of assets to avoid any long-term healthcare costs. if they can possibly avoid it. None of my clients ever start the conversation by raising their hand and saying, yes, I want to go to the nursing home. Number 5, people want to avoid family feuds and family fights at all costs, and be sure that there's an understanding about what's been done, what everyone's responsibilities are, what they're going to receive at the time of death, behaviors expected. That's very, very important. And then people also would like the opportunity to share the wisdom, share the values that they've enjoyed during their lifetime, what they stood for as a human being, and pass on those life lessons to future generations. So why don't people plan? We know we have a lot of negative things happening in our country. We know that there are all kinds of ways that estate plans can explode. We know that people want to set things up to transition to the next generation as quickly, easily, and cost effectively as possible. But yet, millions of people in this country fail to plan. And it begs the question, why? Well, some of us have blind spots. We just don't know what we don't know. And those blind spots have been, maybe they've been created by paradigms that we have, beliefs that we hold. There's so much misinformation and disinformation in the marketplace today about estate planning. And it might come from someone we sit next to at church. It might come from a relative. It might come from our brother. It might come from a business associate or someone we play cards with or go bowling with. So much of that information is just not quite correct. And one reason it's correct is not because of the poor intent of the person sharing it. It's just that what worked for them may not be appropriate for you. Every estate planning client has their own DNA, not just the DNA as we traditionally think about it, but their own estate planning DNA. I can ask anyone 3 separate questions, and I'll get 3 separate answers that will cause each plan to be completely different. So we have these beliefs that form over a period of time, and we act out on those beliefs because we want to confirm what our understandings are. And sometimes that leads us to a poor and unacceptable outcome. Then other people have fear and pain about the process. They play a little hide and seek. They prefer just to avoid it, put it off, and they fear going to a lawyer. They fear investing the money. It's that fear of the unknown that causes people to play hide and seek. And there are other reasons as well, but those are the big reasons why people don't plan. And it's actually more than that. It's just not the points that we talked about. It's also not necessarily lack of knowledge. It's lack of comfort with the knowledge we have. We're not comfortable with what we think we know. We know that there are continuous changes in the law all the time. We know that we hear stories about traditional planning failing because of something that you had to go through with an aunt or perhaps a grandmother or a family friend went through with someone. My point is simply this. Whether it's because of blind spots, paradigms, belief systems, playing hide and seek, wanting to put it off, not wanting to address the difficult challenges involved in setting up a plan, it leads to a lot of confusion. That misinformation, disinformation causes us to put things off and we procrastinate, right? Happens to all of us in different areas of our lives. It's particularly problematic in the estate planning area. So the question is, well, does more knowledge matter? Not necessarily. You may already have enough knowledge to plan, but you may not be quite certain if that knowledge is spot on. So today, as we go through the program, we're going to provide some more knowledge, maybe clear up a few things that are confusing to you. There may be some new knowledge for some of you. You may be hearing things for the first time, and that's great too. But whether it's just clarifying or creating new knowledge, we want that to happen, but our focus today extends beyond that. We really want you to be able to take this information and be inspired and have the confidence to create a roadmap for getting into action and implementing a plan for you and your family. And we're going to show you how to do that. As we go through this, just think about estate planning in a new way. You might even be ready for an epiphany because we're going to talk about some concepts here that may be a little unusual to connect to the traditional estate planning process. And we're going to talk about the ingredients of traditional planning, how sometimes they work, and a new way of thinking about planning, and including steps that will help you address the most important part of this process. Hope you're ready for an epiphany. So let's go. As we begin, think about this question. What is the single most important part of the estate planning process for you? File that away in the back of your mind as we go through the program and just think about this. What's the most important part of this process? A quick overview of why many plans fail. Perhaps poor documents. The problem with the legal profession today is if you call virtually any law firm and say, can you help me with an estate plan, you're going to hear, yes, we can help you do that. They may have a curiosity about estate planning, but they may not really be committed to it. It may be a sideline for them. It may be part of a portfolio. They may have created 2 or 3 or 5 estate plannings over the past few years. I guess I said estate planning. I meant estate plans. They might have created 2 or 3 estate plans over the past few years, but they're really not committed to it. So their knowledge and information might be broad, wide. They might be good at DUIs. They might be pretty good at personal injury, maybe a little corporate work, maybe a little estate planning work. But because of that, those documents may not be exactly what you need, and they may not have the depth and breadth of experience to ask you the questions to be sure that you have a great document. There may not be any protection for nursing home expense, and there may not be a follow-through system that ensures that the assets you owned are correctly connected to the estate plan that you've created. They fail to address remarriage situations. That's happening more and more frequently. We're going to talk about that more. And they fail to keep the plan updated or give you a mechanism to help you keep your plan updated. And then finally, your legacy. The family legacy is not captured in a meaningful way that will allow it to be shared with future generations. Estate plans fail, and there are a few reasons why that occurs. So as I mentioned in the agenda, we're going to talk about these issues in the context of a story about Bill and Mary Jones. Here's what we know about Bill and Mary. First of all, they've accumulated some nice money. They built a nest egg for their retirement, including IRAs, their home, investment accounts. Bill has a business that he has a partner in, and his business, and this is critical, remember this, the business is titled in Bill's individual name, as is a farm that Bill and his brother inherited from their parents. So we have a couple of pretty significant assets that are titled in Bill's name alone. Now, you might be thinking, well, this is about a couple, but you may be, on the other hand, single, younger, older, widowed, perhaps divorced, perhaps multiple marriages, and you may be parents or a single person with young children. Stay tuned. All the points we're going to cover will be especially relevant for you as we go through this program, and we will be addressing both the good parts, the successful parts of estate planning, and the parts that fail as a single person. Bill and Mary have a family. They have 2 children, John and Susan. A picture's worth 1,000 words, isn't it? Here's what we know about Susan. Mid-30s, successful CPA, has a couple of young children, an iffy marriage to Jason, but she's close to Bill and Mary. She's on top of her game. She understands financial affairs pretty well because of her CPA background, perfectly able to handle any additional duties that Bill and Mary may cast upon her in their estate plan. John, on the other hand, still struggling a little bit. He's on the West Coast, trying to make it in the entertainment and writing world, scripting, movie scripts and so forth. But it just hadn't clicked with John. He's bounced all over the place. And every time John calls Bill and Mary to get caught up, the conversation always ends with this statement from John. Mom, by the way, I need more. That's right, I need more money. So John's still trying to figure his life out and has some issues because of the unpredictability of his income stream didn't really have a job per se. And Bill and Mary are a little bit concerned about John, his direction, where he's headed, and his ability to take care of himself, both personally and financially. Now, given what we know about Bill and Mary as a family and as a couple, let's assume that they respond to an invitation to come in for a complimentary consultation. So they come into our office, they sit down, and we start talking about their different planning options. The first one we have a little fun with. We tell Bill and Mary, well, one thing you can do is you can just spend it all. You can be a couple that drives a car like I saw a few years ago, an old beat up Volkswagen. And on the back was a bumper sticker that said, "This is my child's inheritance." So that was the estate planning that that couple had done. They were going to hopefully spend their last check, draw their last check and their last breath on the same day. Realistically, none of us really want to do that because we don't know when that's going to happen. And one of the great concerns that we have, and one reason we help people on the financial planning side as well as the estate planning, is that everybody's worried about running out of money and being sure that they have adequate resources and adequate cash flow during the retirement years to live the way they want to travel and do all the fun things that they had hoped to do during those critical and enjoyable years. We also tell Bill and Mary a little bit about what happens if you do nothing. You don't have a plan now, you have no will in place. So if you walk out of here today and something happens to you, you're going to die intestate. That means you die without a will, right? So here's the key point that we share with Bill and Mary and that we would have you remember. Is don't forget that even though you may not have a plan of your own, the state in which you live has a plan for you. We have a plan for people in Missouri, Kansas, and Oklahoma, where we practice most of the time. Every state has a plan for you, and you're not going to like that plan very well. It's called the Laws of Intestate Succession. And they have a formula by which assets are distributed to surviving spouses and living children, if you have any, and so forth. We would also talk to them about joint tenancy. Now, joint tenancy is a powerful, powerful concept. Let me tell you a little bit about it. There are two types. And let's just assume for a moment that each of my hands represents an owner, a joint tenancy owner. Well, here's what we know. If the joint tenancy is with rights of survivorship and both joint tenants, let me just get a pen here, and let's assume this pen is an asset. It might be a brokerage account or a bank account, might even be a piece of property. So we have owner one, we have owner two, right? Two owners. Joint tenancy with rights of survivorship simply means that when the first joint tenant dies, the surviving joint tenant now owns 100% of that asset. Joint tenant owns everything. And that transfer is by operation of law. No further action needs to be taken except for perhaps filing an affidavit of surviving joint tenant at the courthouse. Now, just a quick side note. By contrast, joint tenancy in common means that when a joint tenant owner dies, that person's interest goes downward, not sideways to the survivor, but downward to that person's heirs. And that property is considered individually titled property. Why is that important? It's what I call the seduction of joint tenancy. Remember this rule. All property that's titled in one person's name will go through probate and pass according to your will, if there's a will in place, and if not, according to the laws of intestate succession. All property titled in one person's name goes through probate. So let's go back and review. Two names on the property, survivorship joint tenancy, one person passes away, the survivor owns everything by operation of law, remember? But now the minute that first joint tenant dies, what's the situation now? Now there's only one person on the title to that property, and now that property is automatically subject to what? That's correct, it's automatically subject to probate. So that's the seduction of joint tenancy with survivorship and the trap at the end. Likewise, joint tenants in common, that joint ownership is considered individually titled property, and it too would have to go through probate. But we talk to them about joint tenancy because it's such a powerful concept, and joint tenancy transfers will trump everything else you do. Bill and Mary could also create a simple will. I, Bill, leave everything to Mary. I, Mary, leave everything to Bill. If neither survive, to our children, John and Susan, in equal shares. Typically called an I love you will. Many times, assets transferring at that point, if they transfer through a will, again, will have to go through probate. Bill and Mary could also set up what we call a bare bones living trust. And that would be a document that would attempt to avoid the probate process and may or may not, depending on what additional steps are taken in connection with the creation of the trust. And finally, we talked to them about a family wealth trust or a legacy wealth trust, a much more powerful approach to creating an estate plan. Well, as fate would have it, at the end of the conversation, Bill and Mary decide to do nothing. They make no commitment. There are too many things on their plate. They have exercise coming up, they have hair appointments, they have upcoming vacations, volunteer work, so on and so on and so on. And lo and behold, they end up doing nothing. They end up procrastinating. Now, a few months later, we get a call at the office. And that call is from Susan, and she says, I know that my mom and dad came in to talk to you about estate planning. I'd like to know a little bit more in detail about the plan, what decisions they decided to make, what role I need to play, how I can help, what's the protocol, what's the process at this point. And we say, whoa, stop just a minute, Susan, what happened? Why this conversation at this point? And they tell us, first of all, that Bill has had a health event and he's in trouble. He's been taken to the hospital. He's not doing very well. They're not sure he's going to survive. And what do? Unfortunately, we have to tell Susan that there's no plan in place. So now just think where we are. You have Bill on a gurney being wheeled into a hospital, health outcome uncertain, suffered a stroke, some other disabling event, to the point where now Bill becomes disabled. So now here's the question. With no plan in place, no life plan, no death plan, what authority does Mary have as his spouse to conduct business for Bill, since he's disabled, incapacitated, no longer able to care for himself? And you're right, this is a problem. It's a big problem. And it won't be reconciled and resolved during that incapacity until we go to court and establish a living probate, either a conservatorship or a guardianship or a combination of the two. Living probate, those two in particular you see on the screen, involve a court process that's designed to protect those who are mentally disabled, physically unable to take care of themselves, and for minors with deceased parents or minors who are receiving an inheritance from a probate proceeding. But that living probate, once established, will continue on until Bill either recapacitates or until the time of his death. Now think about this for a moment. How would you like to have to go before a court, someone you don't even know, or maybe worse, maybe you do know them, and ask for their permission after laying out all your cards financially, and get the court's permission to spend your own money for the care and well-being of your own spouse, and report to them on an annual basis everything about your financial affairs? That's what's involved in a living probate. It's a nightmare for people. First of all, it's humiliating, and it leaves the court in control, not you, not your family. It's also time-consuming, and all your personal financial information is disclosed and made a matter of public record, to say nothing about the expense, those items that you see listed there, including some accounting fees and some conservator fees, court costs, and attorney fees. Problem: no one likes going through that process, but it will continue until our good friend Bill passes away. Now, here's what I want you to think about at this point. Remember the rule. All property title in one name has to go through what? That's right, has to go through probate. Bill and Mary might have received the joint tenancy property by operation of law. She might have been a beneficiary on a rollover IRA or an annuity or a life insurance policy, and all that will be fine. All that should be taken care of in a fairly straightforward way. But that farm and that business is another issue. And because it's individually titled property, Mary may not be able to get control of it until she walks those assets through the probate process, through the death probate process. And so here we are, paying the consequences, paying the price of failing to plan. So what is death probate? Well, you see listed some of the steps that are taken in that process. First of all the assets are identified. You find the assets, you appraise them, you pay off all the credit cards and other creditors, you terminate Social Security. If there are any disputes, you resolve those, you get everything cleaned up, you get everything organized, and finally, you distribute the estate to the beneficiaries, and that's a step that involves changing title to the assets. In effect, a death probate, is a court process to do for you what you could not do for yourself. Or better said, because you can no longer do for yourself what you could do during your lifetime. The orderly transfer of the assets to your designated heirs or the heirs identified through the laws of intestate succession. People say, well, why avoid probate? Well, there are a number of reasons, and here are a few. First of all, probate's expensive. Probates can run anywhere from 3 to 6% of the total value of your estate, perhaps even more. They include court costs, attorney fees, publication fees, executor fees, and so forth. Probate's also time-consuming. Not unusual for a probate to take 18 months. So we always say budget somewhere between 12 and 24 months. And by the way, during that process, as probate continues, you're going to trigger all kinds of additional tax reporting requirements, the filing of fiduciary tax returns and so forth. Many times that has to be done after a death in any case. But the point is, in a probate, it may take much longer than it might otherwise. Probate's also open to the public. It's a matter of public record. That means that anyone can walk in off the street, go into the courthouse, find your probate record, and dig through all your personal financial affairs and learn everything about your family, who gets what, how many assets are involved, and so forth. And then, like our friend Bill, because the property he inherited is in a different state than where he resides, he's going to have to go through multiple probates, an ancillary probate. So those are the 4 reasons people don't like probates. So here's the good news today about death taxes. We may remember when the estate tax exemption was $600,000, and over a period of about 10 years, it was lifted from $600,000 up to $2.5 million, then $5 million, and most recently, because of the tax law change in late 2017, the exemption was raised to $11 million. That means that each person can transfer $11 million of net worth valued assets and pay no estate tax. Or for a couple, that means the number is 22 million. So for the most part, most of us don't have an estate tax issue today. The problem is, what we have to remember is that law sunsets at the end of 2025. So beginning January 1st, 2026, the law reverts back to the $5 million level. And so we just need to be mindful of that, pay attention to it. Right now, there's not a big issue with federal estate taxes. We know that the law has been changed a lot through the years. And beginning in 1916, you can see some of the major changes there. And we can expect those to change again. The estate tax tends to change as the political winds shift. So in the past few years, we've had a mindset in Congress to keep the estate tax low. But with the political climate today, where we're hearing so much conversation about free this and free that and $22 trillion in debt, my guess is there's going to be a grab for revenue to come from someplace. And estate taxes tend to be the centerpiece of many political conversations. And so you can anticipate that the estate tax law will change yet again. We also have to be concerned about state inheritance taxes. The good news right now is that in Oklahoma, we don't have any state inheritance taxes. So again, no problem today from an estate tax point of view or from a state inheritance tax point of view. And the law is currently structured so we virtually never have any tax due upon the death of the first spouse. There may be a little bit of an exception for that if the surviving spouse is not a U.S. citizen. Now, this is a little different in the estate tax or estate planning context. What about Bill's legacy? What about his wisdom, life stories, and experiences? Are all those now gone? Did they leave when Bill passed? And who will know about his values? And to what extent will the family make a commitment to talk about Bill and share his wisdom and life stories and experiences? And we know there's nothing better than Bill telling it. And as inspired as the family might be and as much of an effort as they might be making to tell Bill's stories, it may not have the same impact that it might if Bill himself were sharing those. And so the risk we have is that Bill's story, Bill's name just may be placed in a family tree inside that box, and it may not have any files attached, if you will. No files of the great life that Bill had and what he'd like to share with future generations. So in summary, so far, this has not been a very effective plan. We haven't had any protection from living probate, death probate, no protection from outrageous nursing home expenses, and no way for Bill to pass those values and life experiences on to future generations. Now, after the first spouse dies, now we become concerned about a couple of other things. First of all, what happens if Mary gets remarried? What about creditor claims and lawsuits and nursing home expenses? Have we taken any steps to address those contingencies? And the answer is we have not. We know that because Mary inherited most of the estate, and we don't know what finally happened on the family farm and that business, because by the laws of intestate succession, it could be that Mary received part of that property and John and Susan received part of that property. But let's assume for the moment that Mary received it all. She now has the full command and control of that $700,000 estate with no restrictions on access to it. Ladies, you live a little longer than the guys do. On the average, 7 years. I don't want to hold anybody to that or create any concern for somebody who's at 6.9 years. Just continue to stay healthy and you'll make it much further. But over that period of time, hopefully Mary will manage that money well. We can help her do that. And she'll create a cash flow system that will protect her. Those assets may grow during that 10-year period. And in fact, may double in value. And the estate may grow to the point where it's 1.4 million, 1.2, 1.6. We don't know exactly, but safe to say we can reasonably anticipate that estate should continue to grow in value, absent no catastrophic care issues and no nursing home issues. I got a little ahead of myself on that slide. But during Mary's lifetime, and after Bill's death, Mary has a visitor. Ralph shows up. That relationship evolves, it matures, it grows, and it might evolve into a fabulous relationship, the end of which is Mary and Ralph getting married. Any problems there? Well, maybe. However well-intended it may be, it's also possible, and there's no protection against Ralph and Mary deciding, and we won't make any judgment about who caused what, but those assets get removed from the trust that Bill and Mary set up, and they get retitled into Ralph and Mary's name as joint tenants with rights of survivorship. We know what happens then. If Mary dies first, all those assets are going to go to Bill. Excuse me. If Mary dies first, all those assets will go to Ralph, right? We know that from our discussion about how joint tenancy with rights of survivorship operates. It's also possible that the beneficiary designations on Mary's IRA and perhaps her life insurance policies, if she has any, were changed to Ralph. Healthcare power of attorney forms, financial power of attorney forms might have been changed so that Ralph's now in a position to act on behalf of Mary, and John and Susan have no authority whatsoever to take care of their mom. So control has been completely redirected, and all those assets may end up going to Ralph. And you tell me, if something happens to Ralph, where do you think those assets will go? Out of the goodness of his heart, will half those assets go back to John and Susan? Or do you think they're more likely going to end up in the pocketbook of Ralph's children? Something to think about. During her lifetime, she confronts Alzheimer's, placed in a nursing home. A number of us are going to end up with that same experience. And during that Alzheimer's journey, she finds herself unable to manage her own affairs. And again, let's assume that there's been no additional planning. And so who in the world is going to have control? Who will the court put in charge? Are they going to appoint Ralph, the new spouse? And what rights do John and Susan have as children of Mary? And how's that going to be resolved? And could that cause any potential problems? And the answer is, it's very, very likely. You bet it will. Long-term healthcare expenses can include these four categories. The care might be provided in home. It might be adult daycare, might be assisted living, and it might be a full-blown nursing home experience with skilled care provided. There are only 5 ways to pay for that long-term care expense. Let's take a look at each of those. First is, you use your own money. Pay for it out of pocket. Second, some of you are fortunate enough and thoughtful enough, planned early enough that you might have long-term health care insurance. Critically important if you did. There may be some short-term Medicare benefits. Generally, I want you to remember this. Medicare will not pay for your nursing home. Medicare will not pay for your nursing home. There's about a 100-day exception to that where you may get a little bit of transition pay, but don't depend on it because more people lose that benefit because there are certain steps that have to be taken at each step along the way, whether you move from the home to the nursing home, whether you go from the hospital to the home to the nursing home. All those have to be sequenced just exactly right, and most people miss that opportunity. It's also possible you may qualify for Medicaid benefits. More on that in a moment. Some of you may be veterans and be able to qualify for the aid and attendance program available for veterans. So here's the big question. What are we going to do if Mary runs into a problem? What are we going to do about the nursing home expenses? What are we going to do if she's out driving a car and she gets a little bit careless with it and she's on the front end of dementia, but she's still driving and has an accident? How are we going to deal with that? The liabilities that are created because of that during her lifetime. And then, of course, at her death. Now, all of the assets, unless she's engaged in more planning, all of the assets are now titled in her name. She may have set up additional beneficiary designations for John and Susan to receive an IRA or a life insurance policy, or perhaps an annuity. But we also know that we're going to have to go through a probate, a death probate, the last probate for the family. And again, no death taxes are going to be due because even if this estate grew, At least if the death were to occur today, even if that estate grew to the $1.4 million you see on the screen, no death taxes, but this family will have incurred some pretty substantial costs, some of which could have been avoided and should have been avoided with proper planning. And by the way, this doesn't include any money that might have been invested for asset protection. So back to the question, will Mary's name just appear as a name only, an empty name, if you will, in a box on that family tree? Or will it be an opportunity for Mary to share more about her life, what she stood for as a human being, her values, her life experiences, lessons learned, and so forth? In this case, none of that occurred. So now we've gone through Bill's death, and now we've gone through Mary's death. We've also talked about what happens if Mary remarries to our friend Ralph and does no additional planning, or perhaps starts converting assets from her name into joint tenancy with her and Ralph and the potential problems that may happen there. But let's go back to the basics. Let's assume that Mary kept everything titled in her name. Let's assume that there were no additional transfers. Now what's going to happen at her death, after the probate, after all this is cleaned up, that executor, that personal representative is going to write a check to John for $700,000 and a check to Susan for $700,000, and it begs the questions, how's that going to work? And are these children really prepared for that? We think about that because parents have these concerns after they're both gone. Well, what happens if my children get divorced? And is it possible that after my child receives my inheritance, if they get divorced, that half that may go to the in-law that I wouldn't care very much about right now, that I wouldn't be very happy with? What happens if predators come along and opportunists taking advantage of the children? Or the kids get in trouble with lawsuits? What happens if they have a $40,000 credit card bill and a $100,000 student loan bill? How are they managing their financial affairs? And then finally, if you're parents with young children, what happens if your young children have no plan in place, no plan's been created for them, and you end up creating an environment where both sets of grandparents argue and fight over who's going to provide the care for the grandchildren? So let's take a look at these in a little more detail. I mentioned earlier that Susan's marriage is a little bit iffy. Jason, he works part-time. Sometimes he has a job, sometimes he doesn't. Bill and Mary were a little bit concerned about him. They're concerned about what happens if those assets are commingled with him. And in the case of a divorce, him receiving half. Also concerned about other people taking advantage of John and Susan. And it really continues to cause the question to come up, well, are my kids really ready for this, for that lump sum distribution? And how can I protect and be sure that someone will not take advantage of them after we're both gone? And what about our dear son, John? I mean, is he a walking liability factory? Well, maybe. We don't know exactly what's going on there, but has he been filing his tax returns? Has he been paying his credit card bills? How's he paying for his living expenses on a regular basis? What's going on with him? There's so much we don't know. And we know this, we have no protections in place for him at this point. So let's do a quick review. Summary of an ineffective plan. We know that we had to go through living probate and death probate, not once, but twice. We know that there was no protection from nursing home costs. We know that if we'd had a lower threshold for estate taxes, we might have been exposed to death taxes. We know that we don't really have a good way in place. We're totally exposed if Ralph comes along and if Mary decides that she wants to remarry for whatever reason. We know that there's no protection for the children if one gets divorced, no protection if one of the children gets sued, if predators and creditors come along. And we know that we gave no thought whatsoever to protecting the family values for future generations. So that's version one of the story, a story about ineffective planning and what we see happen so often to people when thinking about their estate plan. They just choose not to do anything. So let's hit the reset button. Let's have Bill and Mary come back in for their consultation, and let's go through those same discussion points with them again. And let's hopefully create a better outcome for them than they had before. And we're going to talk to them about the trust in a little different context than we did before. So now that we have clarity about how an ineffective plan can get created, let's hit the do-over button. Let's reset this discussion and let's move into version 2 of the plan. We're going to invite Bill and Mary back in, and as we think about the options for them and as we talk about the options for them, put yourself in their situation, walk in their shoes, and think about how this might impact you if you were creating a plan of your own. And this time we're going to talk about more effective planning and protecting all their financial wealth, not just the estate planning, the legal piece of it, but also the financial part of it. And we're going to do that in the context of a legacy wealth planning trust, a legacy wealth plan, if you will. And we're going to broaden a number of discussion points, and we're also going to include a couple of new and interesting and fun ideas about how to pass family experiences and wisdom and life's journey on to future generations. Now, the core ingredient of an effective estate plan today is the living trust. Let's talk about how it works. If you think about it, there are key decisions that you have to make. First of all, you're going to want to think about who you're going to have manage your estate from a financial point of view, and who you're going to want to put in a position to make healthcare decisions for you. You're going to have the opportunity to think about remarriage protection. What happens if one of you remarries? Let's go ahead and address that and talk about that and explore the options. And then how do you want your estate distributed? And do you want divorce protection for your children? Or do you want to take care of situations where they may not be quite ready to inherit the kind of money that they may be inheriting? And that includes the timing of the distribution to them. 2 steps to creating a plan. The first is you create the plan. There are a few key words I want you to remember. First of all trusts have these 3 parties. Sometimes you see the trustors referred to as grantors or settlors. All trusts have trustors, trustees, and beneficiaries. Now, trustors are the people who own the property and create the plan. 2 key words. I want you to remember that. Trustors own the property and create the plan. The trustees, as you can see, manage the assets, and the beneficiaries continue to spend the money as if it were their own. So Bill and Mary, and you, if you were to create a trust of your own, will appear in the document as trustors because you own the property and you are creating the plan. Secondly, you'll want to continue to manage the property and the assets inside the property, make all key financial decisions. So you're going to name yourself as trustee, just as Bill and Mary would name themselves as trustee. And then finally, they will want to be named as beneficiaries because they want to continue to spend the money and enjoy life as they're going through their retirement years. And at that point, it's business as usual. Once that trust is created, they can continue to buy and sell, trade, and exchange those trust assets just as they did before. There'll be no new tax forms, no new property tax requirements or increases over and above what may be in place by statute. And of course, because this is a revocable trust, not an irrevocable trust, because this is a revocable trust, Bill and Mary and you would have the option of revoking, amending, changing the terms of this agreement anytime you want during your lifetime. And with your ability to revoke and make those changes, That means you stay in total control of this plan during your lifetime. Don't let anyone tell you differently. You stay in total control. Now, that's the first piece of setting up trust, actually creating the plan. Secondly, though, the key is, and the magic, is how you hold title to the trust assets. And it's critical that we transfer the assets into the name of the trust. So if this is much like a baseball glove, this is the trust. These are your assets. These are your 4 assets. We need to get those assets retitled into the name of the trust so that the trust then controls what happens to those assets, either in the case of your incapacity or in the case of your death. So we transfer title of the assets into the name of the trust. There are 3 exceptions: IRAs or any retirement account, annuities, and life insurance. Those assets continue to be held in your individual name and are transferred to the name of the trust or transferred into the trust via beneficiary designation. So you might be saying, well, why do I create a family trust if most of what it's going to be doing occurs during incapacity or at the time of death? Well, you're right. And in the meantime, it just simply sits there as a standby device, and it springs into effect when you become disabled or at the time of your death with no court involvement. And it's a protective measure for your spouse, your children, and your grandchildren. And here you see the time frame when that family wealth trust will continue to operate during for your benefit and the benefit of your spouse and the benefit of your family, all the way through until the final distribution to your children. Now let's go back to our example, our life experiences. Remember before when Bill became incapacitated? Well, you're right. Remember we had to go through that living probate and spend the money and endure the humiliation and expense of that, continue to do that until Bill's death. We're going to avoid that this time because that trust is going to contain special instructions identifying Mary as the specific person to take care of Bill, and if she can't do it, then Susan. And if Susan can't do it, then, well, maybe, probably, we don't know. We'll talk about having John do it. So the point is there's a chain of command inside that trust that stipulates who can do what at certain times of stress during your lifetime. And we avoid the humiliation, the court cost, the time, expense, and delays of that process. Likewise, we're not going to have any probate because remember, we've taken all the assets and we've connected those to the trust either by retitling them or changing the beneficiary designation to be sure that those assets are transferred to the right person upon death. So there's no need for probate. And again, considerable savings in terms of cost, time delays, ancillary probates, and privacy. All those that privacy will be ensured and most of those costs will be eliminated. No tax issues. We've already talked about the fact that the exemption today is extremely high, making it possible for most of us to transfer assets to future generations without any consequences for estate tax whatsoever. The only caveat being that one caution, that the law as it's currently constructed means that it sunsets and that exemption goes back down to $5 million for each of us on January 1st, 2026. Now here's our friend Ralph. What happens if Ralph shows up? What happens if there's a remarriage? Are there ways that we can protect those assets and ensure that those assets continue to be held exclusively for the benefit of Mary and John and Susan, and that they stay inside the Jones family and not get diverted out to someone else? And the answer is yes. We do that through remarriage protection language. And our clauses will block the estate transfer outside the family, and it will contain specific language and agreements that both Bill and Mary agree to abide by and follow as a condition of managing trust assets in the future. One quick note. Your living trust is not an asset protection tool. Let me say it another way. The revocable trust is not an asset protection tool. That means that those assets are still exposed to creditor claims. That's not why the trust is created. There are all kinds of other great reasons why you create a trust, many of which we're talking about today. But asset protection is not one. So the point is that if you go into a nursing home, the assets inside your living trust will still be countable assets. And those assets, if you want to protect those assets, let me say it that way, that requires additional planning. That may mean that some of you may want to set up a Medicaid asset protection trust and reposition the assets so that you qualify for Medicaid upon entry into the nursing home. But I'll just remind you, you have to start early. There's a 5-year look-back period, and your assets have to be drawn down and repositioned into this new Medicaid Asset Protection Trust for a 5-year period before those assets will be non-countable. And remember, the threshold now is extremely low. You can technically only have $2,000 to your name. So that asset limitation, and there's some income limitations, plus the 5-year look-back period, means that it's very important that you start early if you want to take assets off the table and qualify for Medicaid. That might be important if you have an interest in shielding some of your assets from nursing home expenses and other liabilities as you go through your life. You have to start early. Now, back to our case. Mary gets Alzheimer's again. But again, we're not going to have to worry about much at this point in terms of what plan's been created. Because remember the chain of command we set up? If Bill can no longer serve, and Bill has passed, but Susan's still protected because that legacy wealth plan stipulated that Susan would be in charge to take over and to manage the trust and the assets, to make healthcare decisions, and so on and so forth. And we thereby avert the court proceedings, the loss of control, delays, and the expenses. And again, remember, unless we've engaged in Medicaid asset protection costs, we may still have some significant nursing home expenses, and those will dilute and reduce the value of the estate going forward. We know the rule. Assets and title in our individual name have to go through probate unless they transfer via beneficiary designation. So in this case, there are no assets, or we hope there are no assets, title in individual name. This is where we see many plans fail. This is the step that's catastrophic and takes what otherwise might be a very good plan and turns it into a disastrous plan, because we create the trust, but we don't get those assets in there. For some reason, they keep getting blocked. We don't get them in there correctly because of inadvertence, because of negligence, because of poor legal counsel, because of poor legal work. There could be a myriad of reasons, but the trust stays separate. And any asset that stays outside your trust, if they're separate and in your individual name at the time of death, even though you have a trust, those assets will go through probate. And only after probate will they be transferred into the name of your trust at that time. Bill and Mary, through a legacy plan, will also have the opportunity to capture some wisdom, some life stories, share some values for future generations, and be something other than just a name in a box on a family tree. So now, as we compare the Legacy Wealth Trust to what we did before, it's like night and day. So going through each of those blocks, and I don't need to read them because you can read faster than I can speak them. But as we start in the upper left-hand corner and think about Bill's living probate, through his death, through possible lawsuits, through possible nursing home expense, all the way through Mary's death, and confronting death taxes depending on what the law is at the time, having an opportunity to share values, think about Susan's divorce, John's lawsuits, and ways to protect those. You know, we can do a great job of setting those up. So look, we're going to talk now about that last piece in a little greater detail. Specifically about the question of the distribution to John and to Susan and their preparedness to receive the money when Bill and Mary are both gone. Are they prepared? Well, you can draw your own conclusion. But in traditional planning, those would include outright distributions. With the legacy trust approach, we're going to put some additional opportunities on the table. So let's go through those in some detail. First of all, the concept. So think about your trust. I know this sounds a little bit funny, perhaps. Think about the trust like a tube of toothpaste. If you have an immediate distribution, that would be like taking the cap off the tube of toothpaste, putting it on the floor. You jump as high as you can, and you come down both feet firmly hitting on that tube of toothpaste. You can already visually see where that toothpaste is headed. It literally explodes at the entry point that was covered by the cap onto the floor, sprays all over the room, right? So that would be akin to you distributing your money to John and Susan immediately, spraying $700,000 to them without any understanding about what might happen to it, whether it would be protected, spent right now, subject to lawsuits, divorces, and so forth. So we might, instead of an outright distribution, think about the Family Access Trust. I want you to keep the picture of that tube of toothpaste and think about that tube as your trust, and the toothpaste coming out is your money. So if we stipulated in the trust that Susan's share, because she's financially able to take care of this, but has a little bit of a suspect marriage with Jason, we're going to convey her share to a Family Access Trust and stipulate that Susan is the sole beneficiary of that trust and she can serve as her sole trustee. So she can decide when and if money comes out of that trust and whether or not it goes into a joint account. The pressure to commingle assets is great when someone inherits money. But as long as Susan leaves money in that trust, that money will continue to be her separate property, will not be considered marital property, and in the event of a divorce, it will be protected. We call that a Family Access Trust. John may be a little different. It may be the same concept, but rather than let John serve as his own trustee, we have concerns about his ability to manage his money because of his financial instability at this point. So the key difference with a family-centric trust compared to an access trust is we're going to name, as you can see on the screen, an independent trustee to manage this money and work with John so that he can help them understand when he needs money and what he needs it for and so on and so forth until we may reach a point where John has the financial maturity to take care of it himself. But in the event of divorce, or in this case, lawsuits and creditor claims, that money would be protected as long as we have that independent trustee. The third option might be a family incentive trust, and we see this used more and more frequently. Some families build incentives in, whether it has to do with a full-time job, good grades, drug and alcohol, as you see on the screen, addressing spendthrift issues, gambling issues, and so forth. We've actually had clients put language in the document that stipulates that the distribution to the family can be no greater than the 10/40. So if the family member, whatever the family member makes in the 10/40, that's the maximum allowed in terms of a distribution from the incentive trust. No couch potatoes in those families. And then, of course, families have, or may have, special needs. They may have children with special needs. And if you have a child with special needs, those certainly demand and require the utmost of care in how that trust is created to be sure that if that child is receiving any government benefits, there's no risk of loss of those benefits because of provisions in that trust. And again, that can be done and that can fit the family needs with great precision and great care. So perhaps you can already tell that our approach goes beyond traditional planning. We think that traditional planning focuses on the money. We think that's too narrow. We think the money is important. Of course it's important. It's our primary concern for you. That's another reason that we help on the financial side as well, with the financial planning and the retirement planning. We want to be sure your cash flow takes care of you during your retirement years as you want. But we also know that it goes beyond that. It's an incomplete focus. And we think that the planning should include everything that impacts the family. including your defining moments in life, those emotional anchors of your life, whether they be wedding days, births, deaths, your own special times, and your own special experiences. Here are a few of mine. Me and my family, Hallie and Scott. Two young people there in the top center getting remarried some time ago. Bottom center celebrating July 4th in Washington, D.C. My brother and I in the lower left-hand corner with Mom on her 85th birthday at Williamsburg, and that was a great, great experience. And in the bottom right-hand corner, Scott and Allie, the back left, Allie's husband Mike on the right, with the first of our two grandchildren. That's Dez, and he get that picture updated to include Sage. He'll be very disappointed and angry with G-Pop if I don't get that picture added pretty quickly. But you get my point. We all have defining moments in our lives, and that leads us to a more holistic view of wealth, a view that includes a discussion and recognition of the core values we have in our life, our deepest beliefs and values. Our life experiences and lessons learned that created wisdom, the thing that we all pray for the most. Our community, how we contributed, what we felt great about, and causes that we believed in. And then, of course, being sure that we maximize the financial wealth and protect you and your cash flow during your retirement years. So clients tell us, and you think about this as well. In creating Bill and Mary's plan in version 2, we would want them to talk about these items, talk about these issues. And likewise, we'd want the same for you. All those accrued experiences dealing with all the points you see on that slide. And I want you to think about this. How will you be remembered? What too many people leave behind include the disputes and the hassles and all the cost and the taxes. There's nothing worse than families having to pay taxes that legally they're not obligated to pay and only pay because of a failure to plan. That's extremely frustrating. Hopefully you'll avoid that. You have a choice. You can leave behind planning that works. You can leave behind a memory with your children that you were a good steward in the planning process for end-of-life issues or incapacity issues, just as you were a good steward during your lifetime. This is the why. You heard about my why. You have a why as well. You can take the time to do this and be sure that you do it in a way that protects your family. Remember earlier, I asked this question. What's the most important part of your planning? What do you have to do to make sure that what's most important to you is covered in the plan? You see the answer there. We believe that your choice of an estate planning attorney will be the most important ingredient in helping determine success at being sure your plan does exactly what you want. The reason we say that is because we've seen too many instances where a bare bones plan doesn't work, where canned language doesn't work, where a failure to take into account your specific goals and objectives, your heart's desire, your defining moments do not get committed to that plan. And it leaves exposure points. And it's important that your attorney be a careful listener in this process to be sure that what's most important to you shows up in that plan. Because after all, it's a plan that could last a long time, not just to protect you, but your children and grandchildren as well. I want to share with you what you see there on the slide is referred to as a dirty little secret. In many cases, even though you take the time to set up a trust, they don't work. They don't work because of a number of reasons. Here's one. People come to us, and sometimes they actually have a trust created. And sometimes they've taken a few steps to be sure that that trust works. But guess what? They created that plan 10 years ago. And when I say, well, why us? They say, well, we created this plan 10 years ago. We've never even heard from our lawyer. We've had no contact with that law firm since. That's a mistake. And that's why some law firms fail, because they don't have a systematic follow-up system. They don't have a means of, or a commitment. They have a means. They just choose because they have no commitment to stay in touch with you and continue the relationship to ensure that you continue to think about, talk about issues that mean that your plan will stay up to date. So those plans end up becoming worthless pieces of paper, and assets fall outside the trust. Remember this example? So you might have put 3 or 4 assets in, but over a period of time, you refinanced the home. It did not get placed back in the trust. So now you have 1 asset, maybe 2 assets outside the trust. And there's no attention and no detail given to keeping the plan up to date. Sometimes that's why you see trust documents free on the internet. That beautiful pen with no ink. Worthless. That's what an estate plan with no proper attention after you create it can lead to. This is not a one and done deal. This is not you completing a plan, putting the plan on the shelf, forgetting about it, and going on with your life's business and never thinking about it again. You don't need to think about it every day. You don't need to go over it every day, but you need to be mindful. And we give you ways to be sure that you keep that trust plan up to date. So we just don't want you to be fooled. Creating a plan that works, creating a plan that's appropriate for you takes time, it takes expertise, it takes experience, and it takes some persistence to be sure that you're covered all the way through. Now, up to this point, we've talked about Bill and Mary Jones. We've asked you to walk in their shoes, so hopefully you've seen a dramatic distinction and difference between version 1 and version 2, a totally failed plan, and version 2, a comprehensive legacy plan, and what that can mean to you and your family, and the different options that are created and presented in a legacy plan compared to just a bare bones living trust or a drive-through document. So now I want to share with you a few points about us, a few points about our vision, processes, services we provide that include the client experience. So let me walk you through those with starting this way. We do not know, nor can we tell, what investment would be required for us to help you create a plan. But we'll know after we visit. We'll know after a consultation that we're going to talk about. And our promise to you is that at the end of our consultation, we will give you a fixed investment amount of what it would take to create your plan. We'll also make a commitment and a promise that we will complete that plan within 30 days. And then finally, we're going to commit that you're going to like it. You're going to be satisfied with the service. And I go beyond that. We want you to be delighted with the service to the point where you share our message with everyone you know. So those are 3 key ingredients that make us different. So let's talk about the vision for a moment. One inspired team. And when I say one inspired team, what I mean by one team is we're all on the same page. We're one group of people thinking about you, focused on your family, and being sure that this plan hits the mark square on for you when it's created. And we're inspired because we know the lessons from my father's experience and the experience of other people who have failed to plan. We are inspired to help you avoid that. We hope you are too. We hope you find your why. If you can't find yours, use mine. Do this because you know it's the right thing to do for your family. And when we say committed, we mean we'll do everything we can to be sure this is right. And we're committed to that 100% client satisfaction, where you walk away after this experience knowing that you have a partner and you've created peace of mind from the experience of knowing that your plan, creatively and innovatively put together, whether it's an estate plan, a financial plan, a business plan, those solutions work for you and work for your family. We also have a unique process, a 6-step process that begins with that initial consultation and the identification of a roadmap, all the way up through the design of the plan, the preparation of the plan, the execution and delivery of the plan, the financial review and the risk assessment, and ensuring that assets get funded into your trust correctly, and then a lifetime commitment to communicate with you on a regular basis, hold client education events, and be sure that every 3 years you are given the opportunity to come into our office for a complimentary review to be sure the plan continues to stay up to date. Those represent much different points and a much different approach than you're going to get with most law firms. Here's what's included. Of course, the documents. All the documents you see listed, the trust, a new will, property agreements, a financial power of attorney form, healthcare power of attorney forms, HIPAA forms. There'll also be an owner's manual component, kind of a how-to with this. Concluded, we've just changed this. Not just an audio summary CD, but an actual DVD where we walk you through the specific detailed elements of your plan and the decisions you made with respect to your plan. It's a tremendous tool that you can use to go back and review your plan when you're wondering and wanting to review what decisions you've made and how the plan works. And it's also a wonderful tool to share with your children to give them an idea of the planning that you've created. And we have a complimentary portfolio, shall I say, of complimentary value-added lifetime services. We also have a legacy care plan that will take an even further step to help you keep your plan up to date, and we'll visit with you about that during the consultation. But I talked earlier about appreciation events, about education seminars. You will hear from us 6 to 8 to 10 times a year through newsletter and e-alerts, and we'll be sure that we will help you keep this plan up to date during your lifetime. This is not a transaction for us. This is the first step in a relationship. And then here's a fun thing that we'll also let you do. We're going to give you a book. Each one of you, if you're a couple, husband will get a book that color, the spouse's book's a little bit different color. And in that book, you're going to be able to share family folklore, advice that you'd like to share, words of wisdom, include love letters, heirlooms, pictures, and so forth. People absolutely like taking the time to work through this book and share their life stories and lessons learned with future generations. Now, question is, well, gosh, I'm going to create this plan. I'm going to make an investment of time and my money and your time to help me get it done. But what if things change? Well, they will. I can promise that. And it may be a change in the law. It may be a change in your life situation. It may be new strategies that evolve. And our recommendations may shift. But we will help you keep your plan up to date. And we will help you be sure that when those changes occur, you will know about it. Our firm is also a member of the American Academy of Estate Planning Attorneys. We've been a member since 1993, and we are the only member in Oklahoma. They expect us to achieve very high levels of continuing legal education. It's an organization that provides a tremendous back office research capability for us when complicated estate, elder law, and business law issues come up. And it's a little bit like having a nationwide firm. So, for example, we have clients that move. We have clients that vacation to Florida, vacation to Texas. Sometimes they move to Arizona. And we have the ability to work with lawyers that are members of the Academy in those jurisdictions to be sure you get the service, care, and well-being that you're used to getting from us. American Academy members have also received great recommendations from a couple of key third parties. Money Magazine says that if you're going to look for an estate planning attorney, You can't do better than finding a law firm that's a member of the American Academy of Estate Planning Attorneys. And likewise, Susie Orman, quote, tells readers to check the web for American Academy of Attorneys, close quote. Pretty strong recommendation. We have an online presence. There you see the front page of our website. Go to that website, www.parmanlaw.com. It is content rich. It contains many articles, all kinds of information that will help supplement and augment your estate planning knowledge and help you learn more about this important process. As I mentioned earlier, we don't know where you're going to end up in terms of what your specific needs are on that pyramid of protection. But we know at the end of a consultation, of an hour and 15 minutes, maybe an hour and a half, we'll be able to tell you most of those issues. You'll be able to self-identify where you want to end up on that pyramid. And depending on where you end up, we'll talk about the time required to get the plan completed, the investment required, and so forth. And as you think about that investment, it's an important decision. I just want you to remember, you get what you pay for. Our grandmothers told us that, right? So whether it's parachuting, brain surgery, fire extinguishers, or estate planning, you get what you pay for. And remember, early on we talked about knowledge not being enough, and you need an action plan. What can we do to help you be sure that you have follow through? When do you get started? How do you go about doing that? And so forth. A quick reminder of my experience with my father, him becoming the inspirational founder of our firm, and that occurring only because of what he failed to do, what he and my mom failed to do. And guess what? It also occurred because at that point in time, I was not practicing back then. I was in the financial business. And I didn't have the courage of my convictions to look them in the eye and say, you know what? I've had experience and I've witnessed what happens when people don't plan. You need to do this. You need to do it because you'll have peace of mind of knowing you did the right thing and you did it the right way and you did it for the benefit of you during your lifetime if something happens to you, and when you're both gone, then for the benefit of me, my brother, and my sister. You have a why. It just makes good sense. Don't let that happen. Don't bury your head in the sand about this. Let's be sure that you take the steps necessary to get this plan in place. So let's talk about what those next steps might be. And start from this point of view. Start thinking about version 1 of this program. Doing nothing. That's what Bill and Mary did. And you saw how that worked for them. What was the cost of that failure to plan? What were the cost of failing to plan B for you and your family? We've talked about some of the options. We've talked a little bit about our process. So let's go more deeply into that and let's talk about taking the next step, which would be taking advantage of a complimentary consultation with our firm, coming into our office, sitting down with us, spending somewhere around 75 to 90 minutes, talking about the options, letting us create a rough draft of a design for the plan, and seeing how you might get started. So in this slide, let's walk through the exact steps you can take to set up your consultation. We're trying to make this really easy for you. So the first thing I want you to do is click here on that blue tab to schedule your free consultation. So we're going to click on that. There we have it. So the first thing I want you to do is you would go over on the left and you would select a day. So you go on the left, select the day that you want to come in, and tomorrow there's a time available. I'm going to be putting some additional times on there, but during May, you can see the times available. And just pick a date that works for you, even though it may not appear right now. The 7th is the only day. There'll be additional days, so explore a little bit. By the time you click, there'll be additional highlighted dates available for you. Once you complete that, and by the way, if you want to go into I guess, June, you would just click on this button right here, and that would take you. Right now, you see I've not set up any times in June, but I will. So let's go back to May. And once you click on that, there'll be a series of times. And right now, you see there's a block available at 4 p.m. tomorrow afternoon. So we're going to be updating those, and there may be 2 or 3 on each day, depending on the day of the week, when those can take place. But once you click on that, then you'll confirm it, and you put in your name, and all you have to do is just type it right there. Type your name in. See if I can do that. Easy for me to say, right? Very, very easy to do. My email just happened to go in automatically. Put your phone number in there, your cell number if you would, and you schedule the event. And when you schedule that event, then what's going to happen is it's going to tell you what it is, going to give you a chance to add it to your calendar if you want, and reconfirm that. And so when you set that up, you can put your email in there, and you'll get an automated confirmation time, et cetera, et cetera. Now, here's another great point about this, and something that we're trying to do to make it easy for you. Step 2, fill out this easy-to-use form before the appointment, and remember to bring it with you. So to fill out the form, you just simply click on the form, and I think here in a moment that form will come up. There it is down there in the corner. There it is. Comes up as a PDF. Now, here's what's great about this form. Some of you may like to fill out this information on your computer right here. So, for example, you can just type your name in, etc. You can put whether you're single, whether you're married, and it'll take the correct box, put in your home number, your cell number, your email address, so you can type that right in. And indicate what you own. Have an IRA, life insurance, CDs, ballpark value of the estate. You know, might be like Bill and Mary when they started, might be 700,000. That all of this helps prepare us better, have a meaningful conversation with you when you come in. Yes, I have children, put their names, information about them, whether they're the parent of both of you or husband or wife. So I think you get the feel now for how this works. And then when you're designing your plan, think about this. Who do you want your estate to go to? Do you want it to go to children in equal shares? Yes or no? And if not, what's different? So just walk through those, fill those out, and print off the form. You can actually save that form to your computer if you would like and print it out, but print it out and bring it in when you come in. Some of you may like to print off the form in blank and just fill out that information in your own handwriting. And if you want to do that, that's fine. Make it as legible as you can, but that's the process that you use when you're filling out this information. So you have the form, you see the form, and all you do is click that blank, and that will take you to the form. You pull it up, fill it out, bring it in with you. If you need help through any of that, just call our office and we will walk you through that. So that's what you do to fill out that form. Now, when you come in, here's what you can expect. First of all, you'll be greeted by a smiling face and offered a drink of your preference. It will not be an after 5 type drink, but you'll be escorted promptly to a conference room and seated there. The attorney I will be in very quickly. You won't have to wait very long, absent some kind of an emergency. And then we'll spend about an hour and 15 minutes, give or take. And here's what we hope to accomplish during that meeting. There will also be a whiteboard in that room. And we might even sketch an outline or design, the initial draft design of your plan. And you'll have an opportunity to think about and talk about who you want assuming certain responsibilities at different times in your lifetime and how you want your plan created. What we hope to do is, at the end of that meeting, position you so you'll have comfort in being able to say, yes, I want to proceed. We will have talked about the investment. I will have given you a fixed price, a fixed investment to complete the plan. We'll talk about the timeline, about the 30 days, what happens in the interim, the little bit of homework we need you to do for us, what we'll be doing during that 30-year period, how we'll be in touch with you, and then what happens during the final signing ceremony. We will go through all that in detail. And at the end of that, what we'd ask of you is simply this. Say, yes, I'd like to proceed. Or, no, this doesn't make any sense for me. And either way, it works for us. The no's okay. We would hope that you would plan. We would hope that you like the way that we can help you plan. But either way, we want to put you in a position to feel comfortable and confident about a decision because, as we know, it's not the knowledge. It's the roadmap, it's the process, it's the attorney you work with, and it's about having a game plan and a process and a way to get this completed the way you want it completed. So even our friend Picasso, he was a great artist, did things a little differently, and he makes this statement a little differently too. Sometimes I even have a hard time saying it. Let me try again. Only put off until tomorrow what you are willing to die having left undone. Because we don't know when that death is going to occur. I promise you, Vance Parman did not anticipate his life ending on his way to the farm. So you've earned the right to complete this. Thank you for investing the time, sharing the time with us to go through this information. If you decide to come in, be sure you set your appointment in the next 2 weeks. Do that because that keeps the information fresh. The decline curve on information is pretty rapid after we hear it the first time. If you're married, I want both spouses to come because we can't make any estate planning decision without both people there. And then we talked about the decision, yes or no, and it'll be comfortable for you to do that at the end of our consultation. So as I close, simply leave you with this. What legacy will you leave your family? And what will the kind of planning you choose to do or not do leave in terms of a message for family members left behind you? What will your feet and what will your footsteps in the sand look like based on the decision you make? We would love to help you. We would be honored to have you join our family of clients. We love the people we work with, and we're sure we'd feel the same about you. So come see us, go through the process. We know you'd enjoy it. It's a great, great step in achieving peace of mind for you and your family. Thank you very much for joining us. We look forward to seeing you soon. Have a stunning day.